have others we expand.
Okay, so let's start this all over again. I get it now. Yes, I welcome you to Talking Points on DBS Radio. Good morning to you. So welcome to Talking Points on DBS Radio. It is a pleasure to have you on. It is the 4th day in the month of July. We greet you on the heels of a successful hosting of cricket in Dominica. West Indies and Bangladesh played to they played rather before an exciting crowd yesterday at the Windsor Park Stadium. A victory yesterday for West Indies. There was an excitement on Saturday as well, but the rain caused the delayed start and there were further interruptions because of rain. But yesterday it was a wonderful day and congratulations, I have to say, to West Indies. This morning we have guests on the program. You may recall that some time ago we started discussion on the OECS Electronics Communications Bill. We had 2 or 3 programs already. I think it's more like 2. In fact, the intention for this program is for every other Monday. So we have to look at a different aspect as it relates to this bill, which will really replace the current Telecommunications Act of 2000 and will address areas which are not currently addressed under the current legislation. But in recent times, we have had holiday Mondays and outside broadcasts, but we are pleased that we are on this morning to continue this very important awareness drive. If I were to quickly backtrack on the first program, I would say that we looked at ECTEL, the Eastern Caribbean Telecommunications Authority, ECTEL. We looked at its mandates as well, and we discussed the governing structure as well. I can recall on the very first program, we had Senator Oscar George with us, and we also had the Telecommunications Director, Mr. Benetton Thomas, on the program. And I think we looked at the progress made in the sector, and a lot of information came out from that. Very interesting discussion we had. We looked as well at the way forward, and a very important area as well, we looked at consumer protection. So in terms of going forward, some of the points that you would have raised in past programs we'll emphasize, we'll reiterate, and as of course this sensitization campaign continues. Now on today's program, we will focus on the role and function of the dispute tribunal in the EC bill. And this, my dear, should be very, very interesting. When you hear tribunal, obviously, what would immediately come to mind? So we want to look at this. What does this say? And we have Mr. Thomas and Mr. Nesty as well, who will guide us as far as the information contained in the regulations. Of course, the EC bill is a legislative package, including the actual bill and the supporting regulations as well. Well, I think I have said a lot, So I'll take a pause here. I have to set the foundation, though, as the host, and really provide a synopsis of the areas that we would have discussed in recent programs. So at this time, I go to Studio 2 to welcome my guests, the Director of Telecommunications in Dominica, Mr. Bennett Thomas. And I tell you, this sector does so much in this country. And when you consider they have to liaise as well with the OECS and the NTRC right here in Dominica and other agencies, but we will talk about that as we go along. And I also have with me the Executive Director of the National Telecommunications Regulatory Commission, and that is long, but very important sector, very important department, Mr. Craig Nesty. Gentlemen, good morning, welcome.
Good morning, Ivona, and thanks for having us.
It is a pleasure to have you on. Mr. Nesty, good morning.
Good morning, Ivona. Thanks again for having us.
All right, of course. Yes, I look forward to a very interesting discussion this morning. I made mention that we had a successful hosting of cricket in Dominica, and of course, this augurs well for us, especially, of course, as we started a new month. July just started, and we are looking at how we can enhance what we already have. So it's a good thing to start, with that success in terms of the hosting. All right. So let me welcome you again. And Mr. Bennett Thomas, I don't know if you want to just backtrack on one of the probably key points that we would have raised in the last program. I look at some of the areas that we covered, but even before we go into the meat of the matter this morning, in reference to the past two programs, what would you say what the reviews are, if any, and going forward, what do we look forward to?
Thanks again. Well, from the feedback we have obtained, persons are very much they were very much enlightened and informed about their various rights that they have within the law, and that there were some of them were totally obscure. They had no idea that they had those kind of rights in the law, especially the fact that what came out even very succinctly was the idea that persons now realize that you can ask for individual services without being tied up to another service, as we said the last time. And you would have heard in the past that service providers would almost demand that you take a second service if you do not need that service. And I think from the last discussion that we had, people were informed that if you need just one service, you can get one service without being tied up to another. I think that was very significant. Another aspect that came from that was the idea of the importance of quality, or the quality of service and customer service. How it's important that the customer is critical to the process. They have a say, they have a right, and that's what the program is really about, to enlighten and inform customers on the rights that they have within the law. And once you are knowledgeable of it, you can act in a proper way. So I think these are the two major highlights that came from it.
All right. And yes, we have missed a few Mondays, but we are sticking to the goal to educate the public, because this is so very important. And I really like the idea from the telecoms standpoint, from the telecom sector. You, of course, are head of the telecommunications sector in Dominica. I like the idea about this sensitization campaign, because even for me myself, as a radio host, I did not realize that there are so many aspects involved in all of this. I was just like, okay, it's a harmonized bill for the OECS, and this will put us on the right trajectory. But when I got down to reading, exactly what it entails, I feel that, yes, we have to continue this education drive, and I'm so happy that you are on. But Mr. Thomas, let us look at the tribunal, because we want to focus on that today. And help us understand its makeup.
Okay, so the tribunal will be called the Electronic Communications Tribunal, and it will consist of 3 members appointed by the Chief Justice. Those persons will be there will be a chairperson, and that person must be a legal practitioner of at least 10 years or more standing. The 2 other members of the commission of the tribunal will have at least 10 years training or experience in more than one of the following subject areas: finance and economics, that is very critical when dealing with the sector; ICT, of course; spectrum management, meaning your frequencies and so forth; competition, and that is a very, very critical aspect when it comes to competition, both in terms in how the players play the game. You can have what is known as anti-competitive behavior, one trying to undercut illegally, those kind of things. So you have to set the parameters. And there is consumer protection on behalf of consumers, which is very important. Those persons who are forming that commission, that tribunal, must have experience in one of those areas, at least 10 years or more, and then you have public relations and regulation. So any of the tribunal consists of those disciplines, and notice that those disciplines are integral to the sector. And so we can maybe expand on it later with Mr. Nesty, but these are the conditions that are for the tribunal.
You mentioned finance and management as one, right? One of the conditions?
Finance and economics.
And economics, okay. Finance and economics, and ICT and the other
spectrum management, competition, especially the area of competition laws, consumer protection, of course, and public relations and regulation. So those persons, if they are trained in those areas, and you try to get a little mix, so you can, when the tribunal meets, they can discuss those areas.
Is it relatively like a small makeup, or is it a large body?
Well, just as you said, there, it's made up of 3 persons.
Oh, 3. Okay,
yes.
So I didn't get that. 3 people.
A chairperson, one to be a chairperson, and there are 2 other members.
Very small makeup. So you don't need a large body for a tribunal like this.
No, I mean the issue is really to deal with claims and disputes and so forth. Of course, there is still the NTRC will still be doing investigative work, and maybe Mr. Nesty can address some of those areas. But in terms of the legal, or what you call it, the judicial aspect of it, those persons, as you can see, they are trained legal practitioners who would understand the legislation and be able to guide the commission properly.
So you mentioned trained practitioners. So I take it that there are people who, for some reason, cannot serve on the tribunal. So not anyone.
Well, it clearly states so. It says that they must be legal practitioners. And well, it says that the chairperson is a legal practitioner for at least 10 years, and 2 other members with 10 years training or experience in more or one of the areas there. So they may not necessarily have to be free lawyers, but the chairman must be a legal practitioner. The others can be specialized in finance or economics or ICT or telecoms or spectrum, whatever. But one of the chairperson must be a legal practitioner.
Okay, all right. Craig Nesty, I understood everything Mr. Bennett Thomas is saying, very clear on that. But I still want your take, though, from the NTRC standpoint. So there's a process involved. It's not a wash your foot and come in. I mean, you have to go through a process, and you're looking for 3 people who are well skilled, in that area. How is one considered for a position on the tribunal, Mr. Nesty?
Well, I think Mr. Bennett covered that extensively in terms of the number of years for the person with judicial experience, that is a judge. They need to have 10 years or more standing as a legal practitioner, and 2 other persons with 10 years in a particular field, either finance, ICT, spectrum management, consumer protection, and so forth. I think more interesting to us, though, is why is the tribunal necessary? Yeah, and I think it is essential because the courts in Dominica and maybe in the rest of the OECS may be so constrained with the number of critical matters that they have to deal with, like murder, theft, child abuse. There are a lot of serious issues that they have to face, and whenever we have a telecoms issue that needs a legal minds to address it, there is always a little bit of pushback as to whether or not it is critical enough to bear down on the court at this time. The tribunal now moves all of this away from the courts, so to speak, and allows us a speedy access to a resolution. So a provider with a dispute with another provider, they can take the matter to the tribunal. They don't have to wait for the years and months that the normal judicial process would take. They can actually just go to the get their matter heard at the tribunal in a much quicker manner than the normal judicial process would afford. Yeah. How is one considered for the position of the tribunal? And I think even before we go on to this, there's one other point I want to make quickly, is I've been in telecoms regulation for a little while now, and either culturally or just based on the awareness of the process, I get the sense that most Dominicans do not take advantage of the formal complaint process. I mean, in any 1 year, we probably have less than 10 formal complaints coming to the NTRC. And that's not to say that there are only 10 issues in the market. I mean, people complain a lot, but they complain on the radio stations, they complain on Facebook, they complain on many other avenues besides following the official complaint process, which requires you putting a complaint down on a prescribed legal form. So what we've been trying to advocate for at the NTRC is having sort of like an informal complaint process, which the FCC has seen merit in having. The FCC is the Federal Communications Commission in the United States. And they also have an informal complaint process because they recognize that not every complainant wants or desires to go through this formal complaint. Yeah, so I just wanted to throw that out there. For the people to become members of the commission, members of the tribunal, the commission will have to compile a list of persons annually who the commission believes are eligible to be appointed as members of the tribunal. And we will submit that list to ECTEL for record keeping. The tribunal, as I understand it, it would not be a tribunal for each ECTEL country. There'll be an ECTEL tribunal. So any matter from Dominicus and Lucius and Vincent, Grenadiers and Kitts can be heard at that tribunal, right? And modern technology does afford us to do this remotely and virtually, so that shouldn't be a problem, all right?
All right, very interesting. So you're saying this list has to be submitted to ECTEL. There's a process involved in all of this.
Yes.
It's not just drawing up a list and then we say, okay, let's go ahead.
Right.
You have a process to follow.
Yeah, so each country basically put forward either the Chief Justice with 10 years legal experience, the ICT specialist, the finance and economic specialist, and I think the final decision would probably be made by ECTEL with the Council of Ministers deciding who will sit on that tribunal.
So Mr. Thomas, is there like the need for due diligence? What is happening from ECTEL standpoint, though, when this list is submitted?
Well, I suppose in every system and process, it is important to do due diligence on persons. You want to make sure that persons are fair-minded, that they have no particular association with the service providers. They don't have a particular interest that will necessarily cause some kind of partiality to the process. So it's important to do due diligence. I mean, I can give you John Brown, but you do not know why I gave you John Brown. John Brown may be qualified, but then he or she may have their motives for being there. And so it's important because you are trying to be as fair as possible to both parties, well, all parties. You want to be fair to the consumer, you want to be fair to the service providers, and of course you want to be fair to the government and so forth. So you try to get somebody that has a clear thinking process and I think. So yeah, their due diligence would be important.
And this list, I guess, can be tweaked as well. So if for some reason someone who is on this list, ECTEL feels that this person should not be there, you go through another process.
Well,
you would have to.
That's up to them. Really.
Okay,
That's
I just want to get this clear
as
to how this is being done. By the way, we are on to Talking Point and we're discussing a very important subject as we look at the EC bill, the Electronics Communications Bill. As we mentioned, we started a series of programs for some time now, and the goal is to really educate the public on various aspects of that bill. What is in it for them? And there's a lot of benefits that people can derive from that. So the education aspect of this is very, very, very important. And there will come a time when, of course, this bill will be brought to Parliament, and then it will be enacted. And so we can move on. But it's important, of course, that we let you know how important this Electronics Communications Bill is. What we will do is just recognize the contribution of Flo Dominica, because what Flo has done is to sponsor the 1-800-327 number, toll free. So let us recognize Flo, and then we will continue with the discussion. Stay tuned.
In September 2017, our lives here in Dominica changed forever. Hurricane Maria took our homes, lives of our loved ones, and left us with billions of dollars in damages to repair.
We at Flow were not immune to this destruction, but we made a promise then and there to rebuild with you in mind. We invested millions of dollars to bring you fiber internet. Not only is it 6 times faster, but we are offering this at no additional cost. We've all been through a lot for the last couple of years. So come on home to Flow and receive 50% off your mobile bill every month when you bundle and win big daily this summer with every transaction you make. Come home to Flow, Dominica.
And we continue. Welcome back, our guests in studio, Telecommunications Director Mr. Bennett Thomas. And we also have the Executive Director of the NTRC, the National Telecommunications Regulatory Commission, Mr. Craig Nesty. Dominica, of course, is building awareness on the draft Electronic Telecommunications Bill. So I said telecommunications, it's communications bill. I'm coming to you, Mr. Bennett Thomas. So what really the government has done is it has joined ECTEL in pursuing this sensitization campaign on this harmonized bill. And there are several benefits, as I mentioned, for you, the consumer, for you, customers. So we looked at this in earlier programs, and as the programs unfold, of course, you will realize, how many benefits are there for you. And yes, the discussion continues. Yes, Mr. Bennett Thomas, you were saying?
Yes, I wanted to just expand further on our last discussion relative to the issue of transparency and so forth. It is one of the things that we, to ensure that there is that level of transparency and who cannot serve on the tribunal.
And even before you go on there with this, let me just let listeners know as well that they can view the program as well, because we are also on Facebook Live. So yes, Mr. Thomas.
Yes, so persons who cannot be on the tribunal is anyone who holds or is beneficially interested in more than 5% of any stock, share, bond, debenture, or other security in a licensee.
Say this again. Let me get
anyone who holds or is beneficially interested in more than 5% of any stock, share, bond, debenture, or other security in a licensee. That means the person who is licensing, the players. Anyone who has a financial or other material interest in any products, patent, or patented process used by a licensee. If one is employed by someone providing an electronic communication service, because obviously you can see the issue right here. Anyone who is bankrupt.
Interested, eh?
Yes. One who has been declared by the court to be physically or mentally incapacitated by reason of soundness of mind. Obviously, you wouldn't be able to do a thing. Anyone who has been convicted of a criminal offense, where the only exception here being a minor traffic offense.
So you have to have basically a clean police record. A traffic offense, yes, a minor one, but a clean police record,
and a member of parliament is not supposed to be on it. So these are the conditions. These are clearly persons who cannot be on it.
Okay, so there are several reasons why some people just cannot be on this tribunal. This tribunal is guided by, regulations. Let us look at the functions, though, of the tribunal. Mr. Thomas, we looked at we looked at the makeup of the tribunal, who cannot be, why it is necessary. What about the functions of this tribunal now?
Well, the functions of the tribunal is to hear and adjudicate claims with respect to disputes between licensees and the public involving alleged breaches of the Act. So if, as Mr. Nesty rightly pointed out earlier, if there is some kind of dispute and some kind of breach of the Act, then between the licensee That means whether it is the provider and some consumer or group of consumers, then the tribunal comes in and adjudicate the matter. And also, any claims with respect to the disposition of an investigation or application made to the Commission. So again, here comes the Commission to play an integral role in that process. Now, the Commission, Mr. Nesty can explain further. Notice that the tribunal is more judiciary in function, but the Commission can do some level of investigation into the matter. And of course, I suppose, work in collaboration with the tribunal. Mr. Nesty.
Well, I wonder if I may just interject here briefly. In the old Telecommunications Act, under the dispute resolution regulations, the Commission could sit as a tribunal. So in the existing Telecoms Act, the Commission could do everything. Investigate, sit as a tribunal, pass judgment, render judgment, and so forth.
So this is what entails now?
No.
Yeah.
Yes.
So what the legal minds have found was that we were judge, jury, and executioner. And
or you call it chief, cook, and
bottle
bottle
washer.
washer.
Yeah, something
Yes.
like that. Yeah.
Yes.
So there needed to be some separation of powers, right? So what has happened with this new EC bill is the NTRC will retain the investigative role, and this new tribunal will act as the judiciary, providing judgments on any investigative matters that we bring to them, or other applications made to the Commission by other people. But there will be a separation, a complete separation, so the NTRC will no longer be rendering any judgment on these issues. Right?
Interesting.
And we hope that this will be a much fairer situation for the providers and the customers in the market.
Because as Mr. Thomas alluded to, the tribunal is more judiciary in its functions.
Yes.
Interesting. So that means that the tribunal will now have more power, more teeth to bite.
They have
do
more
I get it
power.
right?
Yes. And they have the power to issue summons for attendance of witnesses, examine witnesses under oath, right, and affirm or otherwise, compel the production of documents, and a person who refuses or omits without sufficient cause to attend any of those summons is liable to a fine of $1,500.
$1,500.
Yes.
Compel production of documents. Let us go back to this. Explain to me. Give me an example. Of course, I understand, but we have to let people, be clear on all of this.
Well, there may be, for example, a billing issue with a telecommunications provider. Customers may have called certain numbers and they found that their credit evaporated because they were probably being billed erroneously. In order to determine the true cause of that, you would need the billing records from a telecom provider, for example. If we assert that that is the case, the tribunal could compel them to provide those records for us to for the investigation to proceed. So any document records that they need to produce, they would have to produce them.
So, Mr. Thomas, this is not a tribunal by design; it's functional.
Yeah, and just to follow what Mr. Nesty has said, from the time you're about to make a call, those records are traced on the provider systems. So if you are doing an investigation, as Mr. Nesty said, to find out the source of the problem, it is important that you do a root cause analysis. Where is the problem? So you can trace from the time you start the call, and you can see what happened. They have all the records. If they fail to produce the record, the question is why. If you are billing correctly, there's no issue.
That's why paper trail is important.
That's
why it's important to document.
Yes. So if you should have no problem. If the customer tells you, "Well, I $500 for that call. What did I do?" Well, show me the records. If you fail to do so, then why are you seeking to hide the document? So that is why documentation is critical, because the tribunal has to make a determination, and it needs the facts, and we know that facts are critical to such investigation. So you have to provide the documents.
And even Mr. Nesty, this goes back to something we would have said on the last program as far as documents are concerned, because even consumers, even the customer too, they have to ensure that they have their documents in order as well. Whether it be bills or whatever, you need to have these supporting documents if you want to go further, Right, Mr. Nesty?
I would say yes and no.
Okay, well, tell me. Interesting. I like that.
It would help if the customer has documents,
Mm-hmm.
but the telecommunications providers are obligated under law to retain those documents for a certain period. I think under the, but Mr. Bennett is saying 7 years, but I'm not so sure it's that long, and I'm not so sure what it will be under the new EC bill. But there's a period of time that the providers must retain all copies of billing information and so forth.
So let's say I want to take up a matter, but I can't find the correct document. But I can remember it was 2 years ago. I maybe remember as well, it was in the month of August. But I cannot pinpoint my I don't know the exact date, in fact. How do I go about this? Because you said that the company would have to have the supporting documents. But if you yourself are not sure about the date that you could give them to get the supporting documents, so just help me understand.
Well, you could probably ask for a period. You probably say you want to investigate the last 2 years of my bill.
All right,
because
interesting.
you feel that there was some errors, and you could request the data for that period, and they should have that archived up to a certain number of years. I am not 100% sure what that time frame is, but it's definitely more than one.
Okay, so I can say I want to look at my bills for the past 2 years.
Yes.
All right, interesting.
I mean, look, think of it. The onus is not really on the consumer.
It's on you. It's on the company.
The service provider has all of those records.
Yeah.
And furthermore, there should not be. You see, I always try to tell people that the purpose of these processes are not for antagonism. If you are providing a service to the consumer, you have the interest of the consumer at heart also. So if the consumer says, look, I mean, I have been paying you I've been a loyal customer of yours, and all I'm asking is I have an issue here which I want to clarify. You don't have to make that wish a tribunal.
Yeah.
You can simply sit down with the customer and say, look, okay, I'm going to look, as Mr. Nesty said, let me take the last 2 years and take a look, or the last 6 months. Okay, yeah, I noticed, okay, so let's come to an agreement here on something, and you don't necessarily have to come to a tribunal for simple matters of this. When both parties need each other, the consumer uses the service, you are providing a service to the consumer, your interest is to try to ensure that the consumer is satisfied with your service. And if there's some kind of complaint or some kind of dispute, let's work it out before that has to escalate toward the tribunal. So I think a lot of the work of the tribunal could be done by collaboration with consumer and service provider to clear up certain basic things.
So we have ascertained that the tribunal has power. The tribunal can bite. It has enough teeth to bite.
Yes.
And Ivona, in the current act, all the NTRC could do really was recommend to the minister that they revoke, suspend, or revoke or suspend.
You laugh at this, Mr. Bennett Thomas? Why?
Because a lot of people start saying, oh, this is a drastic, draconian measure.
Yeah.
But look, if you are trying your best over the years for simple matters that we're discussing, and because of the critical need of the service to the country and to consumers, it is said that telephony is a lifeline, communication is a lifeline. That's true. And nobody wants to go and hack out the system just because of some issue. And because you might be aware of that, you should not abuse your privilege. The law does provide for the revocation and suspension of licenses of the service provider. Now, you might call it a draconian behavior, but that is in the law. That is why I think it's important that the EC bill, I think they looked at different areas. Okay, can we stop you for 1 day? Can we stop you for a few hours? Can we give some kind of escalation process? But the law must have certain amount of teeth. There must be some kind of thing to do to put some kind of deterrent, or otherwise you simply abuse the consumers.
So on that note, what's happening under this current framework is that the tribunal, which we've established, they can order compensation be paid to the injured party by the abuser, right? So they can order the restructuring of the license. They can order the cessation of abusive conduct or specify changes in conduct of the licensee to limit the abusive aspects. So their remedial measures can be more granular, so they can actually target the problems that are occurring in the market and provide some sort of redress to them.
And it's not only to the consumer. You can have complaints between licensees. So you can have, see, given Wireless has an issue with Flow, with Digicel and Digicel vice versa, or Epic or whatever. And again, the tribunal comes in and tries to rectify those matters.
And this has to be speeded up. Hence the reason for this changing and tweaking of the regulations.
Because you see, especially when you have players who might be dominant, or might have a greater market share, and then you have persons who are new to the market, players who are new to the market, there is that usual tendency for the dominant player or the more established player, the incumbent, to begin to play strong arm and prevent you, and what they call put up regulatory barriers and to prevent you from breaking into the market. That is not the intention of the law. You are acting, so to speak, in an anti-competitive behavior, because you are seeking to undermine and prevent another player and breaching the actual laws of the country. So that is where the tribunal again comes in and say, look, your behavior is not right. We are living in a liberalized environment. You have to provide services for the new entrant, and as a result, you cannot put exorbitant barriers so that they cannot enter the market. So, for example, let's say John Brown has a company, and the incumbent, you have poles. You're not in the business of selling poles and making money from poles, but they want to use the poles because it's part of the infrastructure. You put some very exceedingly high cost for the rental of a pole. The guy cannot even start putting the first pole down. That is anti-competitive practice. You are deliberately inflating your prices to prevent him from accessing the market. So that is where the tribunal comes in and tries to facilitate those processes, because you are not in the business of selling poles or renting poles. You are in the business of providing telecommunication services. These are just infrastructure facilities to allow the other player to come in, and you are making it difficult, very, very difficult.
And like this, the tribunal looks at the interests of everyone, not just the consumers, not just the customer, but service providers as well. They too stand to benefit from this.
That's correct.
Wow.
And the new entrant who's coming into the market, the losses that they would have incurred, like suppose they had investors behind them backing their initiative, and for some reason they cannot deploy because the incumbents are frustrating that process.
Yep, and that can happen.
The tribunal now can decide a level of compensation be paid to the new entrants in the market. Yes, to stop this anti-competitive practice. And that is quite different from what we have in the existing Telecommunications Act. In the existing Telecommunications Act, we are reduced again to suspension or revocation of the license for anti-competitive practices, which no minister in any of the OECS regions would want to initiate. So basically, the providers are aware that it's basically, how would I say it, toothless.
It is when you
but this new act will seek to address that sort of situation.
It is time this bill becomes law then. It is time that we pass this.
No, interestingly, as Mr. Nesty has said, he said if a licensee is in breach of Part 8, and Part 8 deals with the competition among players, the tribunal can order, as he said, compensation to be paid to the parties injured by the abusive conduct. They can order the restructuring of the license, and they can facilitate and approve settlement with the aggrieved licensee. So here is the impartial authority saying, look, your behavior has been deemed anti-competitive. Your behavior has been deemed to subvert the industry, and you have hurt the other party in trying to do basic things that the law has allowed them to. As Mr. Nesty said, the person may have their investors at the back of them, and they have spent thousands of dollars. We know what happened during the early days of mapping and so forth, and the amount of fund. Because one of the things they do is they either degrade your service, delay your service, and as a result, you are wasting money, fighting litigation when you should be in the market providing services, and that is a loss to the new entrant who want to come in. And as a result of this behavior, if the tribunal has found now that you have behaved in such a manner and you have been abusive, they can then tell you, okay, you need to pay for and compensate the player for what you have done. I
like the reference you brought with mapping, and you mentioned fighting litigation, whereas you could be spending all that time providing a good service to people. Interesting. So I really have to congratulate the players and the movers and shakers who sort of drafted this bill, because when you look at it in its entirety, when you look at the various aspects, I mean, it really says a lot and it really suits the time. It comes at an opportune time, and we really need these changes for us to move forward. I'm sure you'd agree, Mr. Craig Nesty.
I agree with you totally, Ivona. I mean, when the existing Telecom Act was passed, it was passed when we had a monopolistic environment.
Yeah.
And the whole purpose of that act was to create liberalization, to liberalize the market. Right now, we have a more mature market, and we have competition issues that are just not being addressed, or the framework wasn't designed to address them. We also have new technologies like the internet, for example. In 2000, when the act was passed, few people envisioned that the internet would be as critical as it is today for business, education, healthcare, and so forth. And this act basically seeks to manage the effectiveness, I'm lost of words. But this act we would seem to basically manage the internet service much better than the old act sought to do. I just got a question from someone who sent me a WhatsApp. They wanted to know how are we telling people what business they are in. Well, the act doesn't really tell people what business they are in, because they're saying that you can have new products and new markets opening up, and it seems like this act might restrict these new entrants into the market. The act is very clear as to the services that it addresses, and the minister will through an official gazette determine what services will fall under this Telecommunications Act. So not every telecommunications service, for example, will be required to comply with all aspects of the EC Communication Bill.
Interesting. I'm just wondering that in terms of what is happening now, and when you look at what is to come, what is happening now could very well be frustrating service providers and putting us, at a disadvantage, the customers at a disadvantage. So let's hope that this will come into effect very, very, very soon. If you're just tuning in, welcome. We're discussing tribunal matters as it relates to the EC bill, the Electronic Communications Bill, very important bill to be passed in Parliament. Hopefully later this year. I'm really hoping that this year we can see this, becoming a reality, because when you look at the benefits for us as customers, the service providers as well, because if it's easier for the service providers to do business, then it will redound to our benefit as customers as well. But when you look at how important this piece of legislation is in terms of moving forward, you can only call for it to be enacted, and enacted very soon. Earlier on, we looked at who can serve on the tribunal and who cannot serve on the tribunal as well. We made that point. But what about the duration of appointments to the tribunal? Is there a clause which looks at remuneration and allowances? Tell me what entails in that regard.
According to the Act, a member of the tribunal holds office for the period that the claim is heard, but is eligible for reappointment. If the chairman or another member is absent or may be unable to perform the functions of his or her office, the Chief Justice or the Judicial and Legal Services Commission may appoint another person to act temporarily. Any member of the tribunal may, at any time, resign from the office by notice in writing addressed to the Chief Justice or the Judicial and Legal Service Commission. And the Chief Justice or the Judicial and Legal Service Commission may, at any time, revoke the appointment of any member of the Commission, providing that a 90 days notice. It says that the Commission, on the recommendation of ECTEL, shall appoint a person to be secretary to the tribunal. And so there is a period of time, duration of the appointment of the tribunal. Once the matter has been addressed, the particular matter concerned, then that matter is done. That is taken care of.
Right. What about allowances and even remuneration and things like that? Is this like something that you can discuss at this time? Is it too premature?
It will be stipulated in the
appointment
EC regulations.
But there's room for that.
Yeah, there's room for that.
Yes,
and I think what we probably should be clear on is that the tribunal is not a body that sits when there is no matters to be heard. So the tribunal will be spun up at any time to deal with an issue, and the tribunal will last for the duration of time that issue is to be resolved.
Interesting.
There are measures in place that if they find if there are shortcomings of members of the tribunal during that time, that they can be removed from the tribunal. But the essence of the tribunal is really you form the tribunal when the issue occurs to deal with that issue.
And it does not mean that there will be several matters that the tribunal will have to look at any given time. You deal with one matter. Help us understand how this is.
Well, the timing of
one
that,
complaint at a time.
The timing of that has not really been determined. Typically, I mean, if the tribunal has already constituted, and you have another matter that has come to the fore, that tribunal might be well positioned to deal with it, as opposed to forming another tribunal to deal with that situation. But if you recall from earlier on, you realize that every year the NTRC submits a list of members that they feel are suitable to serve on the tribunal. So Dominica will submit their list, St. Kitts, St. Vincent, Grenada, St. Lucia will submit their list. So the ECTEL will have that pool of resources to constitute a tribunal at any one time.
All right, very interesting discussion. If you're just tuning in, not many calls on subjects like that, and we really don't mind. The thing is, I know that people are listening. I'm getting some suggestions. I'm getting some, feedback. So people are listening. But I want us to go back to something that we spoke about earlier, because someone might just be joining in. We are talking about the tribunal. Just help us understand again, Mr. Bennett Thomas, why this is necessary. Why a tribunal?
Okay, even under normal circumstances in everyday civic life, if you have matters that needs this clarification or a complaint come up, you want to have some kind of body or institute that can help you facilitate that. Even in the normal court system, we have, because there was, as Mr. Nesty indicated earlier, there was having a backlog of cases in the judicial system, and as a result,
just take a pin there. Let's see if this person wants to share before you continue. Yes, you're on. Good morning.
Good morning, Yvonne.
Hi.
And good morning to your guests. And
Good morning.
it's not like maybe we don't want to call. I guess people trying to absorb sometimes.
Okay, I know.
Big words can deter your liquor. But I just wanted to seek your permission, Ivona, to
Go ahead.
divert a liquor. Can I do that?
Okay, let's see. Let's see if it keeps in line with what we're discussing.
Well, it's a little out of line, but that's why I wanted to seek your permission.
Well, my guests will decide if they want to answer now or leave it for another program, because as I said, we have a series.
It's an ad I heard of one of the providers, and to me it really turned me off. And you're telling me to bungle up so I can come to VIP and have a drink and have a it turned me off. So I would really like to hear, because I can remember in a previous discussion you had with him, he said that the thing about trying to bribe people and sending out things is somehow an offense. To me, I can recall the last time that you had it.
Yeah, we touched on that.
So I just wanted to get his views on that, because it really turned me off when I heard that.
Okay.
Thank you very much.
Interesting point. Mr. Bennett Thomas, I'm not sure if you...
No, I'm not sure if I get it. I think...
He was talking about, I think, a service provider with a promotion, talking about... It was for the cricket. But it goes back to what we had discussed on a previous program, as it relates to what service providers do at times in terms of the package that they want you to take. So it's along that line.
No, but you don't want to make a confusion between an advertisement for the public display, which of course that advertisement should not undermine or in any way breach the laws. But there's a difference between their advertising their service and being anti-competitive in your behavior.
So we have to look at this separately.
You
have to look at each situation in its own merit.
That's correct. You take a look and see what they're saying.
Okay.
I mean, if you are telling me to come to the party because I want to give you a reduction in your bills going forward, that's a serious issue. But if they have an advertisement saying, if you want to come to my booth, come and have a drink, they have a right to advertise how they want. But that is not the same matter as being anti-competitive or trying to undermine the process. So you have to be careful as to what clarification on those matters.
All right.
So
I think we need to be clear on a few things. Whilst we recognize that bundling may be problematic, bundling is also an essential strategy in telecommunications.
Right.
Sure.
Right? So what the law says is that you can bundle anything, right? What has to happen is all of the services in the bundle must be offered above cost. So you cannot bundle something and sell something below cost. Like you cannot have internet for like say $190 and say $5 more is TV.
$5 more is TV. That's
Right.
unfair advantage to the other
because
service
the
providers.
TV may be afforded below cost
All right.
because the cost of the TV might be XYZ. The other thing is any service in the bundle must be available to the individual individually.
right.
So you cannot have a bundle service and I cannot come to you and say, okay, I don't want the bundle, I just want A in the bundle. You must be able to provide me
Okay.
any service within the bundle.
Yeah.
And if you're doing those things, then you are well within the law. The problem arises when you do not give the consumers the opportunity to get the individual packages in the bundle.
All right. Let's go back to the telephone quickly. You are on. Good morning.
Yeah, well, I am away from radio, so I didn't hear clearly if he said anything about. But what the provider is saying to bungle up. You're telling me you're giving me a package for Friday, Saturday, and Sunday. You're telling me bungle up, put everything together, and come now to have eats and drinks in your booth. That is what it was telling me. I am saying I pay maybe more for that bungle up, which I'm going to have for a month if I continue to have it or whatever it is, to come and have a few eats and drinks that ended yesterday. But I still have the bungalow package to pay because you asked me to bungle up. That's what I was saying. Thank you.
All right. So to bundle or not to bundle? That is the question.
But I vote at the end of the day, the marketing people,
Yeah,
they
it's
have
a
a job to
strategy,
do,
yes,
and
Yeah.
they want to try and get as much revenue as possible. And the consumers need to be educated as well
Right.
in order to take
Yeah.
the best option
Is-
possible.
yeah.
Right?
Yeah.
If it suits you, take it. If you don't want it,
Yeah.
you leave it, right? Let's go back to the telephone. You are on. Good morning.
Hello, good day.
Hi, good day. Hi.
Yes, okay, Mr. Thomas and Mr. Nesty. Very interesting. I want to pick up on the last caller thing about not to go out of what Oli was saying and not to keep to his point, but my concern is that what in the regulation and in the bill that Oli is putting out that gives customers, the right to take action against providers who discomfort them. What I mean, I'll give an example. For example, the cricket. Saturday, they brought it, they will stop it up. Sunday, after the first over, they just put it out. And they put in a stroll on the screen, you are not subscribed to that channel. Call your provider. Call the provider telling you, management say to take it off. So I want to know what in the bill that you guys are talking about, which I find very interesting, a lot of good things in it, yes, that the customer has to take action and to get redress for this kind of discomfort. Okay?
Right.
Thank you.
Okay. I'm not sure you heard it. You clearly understood what he was asking.
Yes, I mean, I'm not here as a legal scholar, far from that at all. But there's an issue of marketing and so forth. Okay, the service providers do pay certain their big price, their cost for their service to bring the cricket to Dominica. Usually, I mean, I'm subject to correction on here, but usually, if this service, the cricket is being played in the host country, in most countries they choose not to show it on TV, because on the purpose of that is for you to go to the grounds. So they have that right, I suppose, to say, okay, if you are in the host country, we are not going to show it. All right? Whoever is providing the TV service, all right, they can choose not to do that. But again, I am not a legal scholar on this matter, and so I'm not going to say that. But I think in most countries, when they have this kind of cricket, the service providers who are paying exorbitant costs for to bring that service to the country can choose not to do so, and they make their money by broadcasting it to other stations and others, so forth. But I think it's a marketing issue, and it does not necessarily mean it is a violation of the act. If you want to see the cricket, then you have an option to go to the grounds to see the cricket, or listen to it on the radio. But you want to stay in the comfort of your home and dictate to them that you need to open it up. Well, they can do so, but they might just do it on a pay-per-view basis and tell you if you want to see it at home, then pay-per-view. They can do that.
I think the issue Mr. Bennett is raising is one of rights, the copyrights for the game, and the telecom providers may not have the rights to broadcast the game in Dominica, right? And whichever telecom provider that was broadcasting it may have realized that late in the game and may have taken corrective actions to address this, because these rights are sold to different broadcasters, like you would know.
Even in radio for us. I mean, we could carry it on radio, but we could not carry the game on on our Facebook page or on YouTube.
Exactly.
We could carry the entertainment part, and people were coming in and and the cultural activities go on. But as the game itself, we did not have a right to do that.
So that's the issue of the rights. There's also the other issue. If the service was interrupted for whatever reason and didn't have anything to do with the rights that the provider had to carry the game or not, then you're running into a quality of service issue.
Okay.
And the consumers do have redress when you stop providing a service because of network outages and poor service and so forth. These are now quality of service issues, and consumers can make complaints about poor service based on quality of service issues.
Right.
I would like us to look at this more on another program, though, Mr. Bennett Thomas. So in future programs, I think we have to look at that specifically as a subject. We are still getting calls, but we have to end. It's already 10:30. I can't believe this. It's already 10:30. Very interesting this morning. What came out of this as far as the tribunal is concerned. I'm sure that the next time you come on, we could also continue to give more details on the tribunal. It is very, very important that we are very clear as to what entails as far as the Electronics Communications Bill. So I'm hoping that the next time we can look at this a little. But as we end, we have another program coming up. I can see my guests are here already. Let's get closing remarks from you, Mr. Nesty, quickly, and then we'll hear from Mr. Bennett Thomas.
Well, quickly, I just want to say a decision of the tribunal is binding on the commission and is enforceable as though it were a judgment of the High Court. So the tribunal that's being formed for all intents and purposes is going to be very serious.
Powerful body.
Yes.
Yeah, and on my end, all I'm saying now that the consumer now has an avenue where they can now bring their complaints and to get some form of redress, both from the consumer standpoint and even a licensee who may have issues. So there is now in the law some form of redress.
All right. Okay, well, gentlemen, we thank you for joining us. I'm hoping that the next time we won't have an interruption and that we can continue this series of programs, as we planned. As I said, we have had a lot of we have had a lot of holiday Mondays in recent time and outside broadcasts, so sometimes, that will prevent us from having our regular program. But I really enjoy this discussion. I think it is necessary. Yes, there can be technical terms, but we seek to break it down, because really we want people to understand what is in it for all of us. So thanks again, gentlemen. I think it's not next week Monday, but on the 18th, we will meet again.
Okay.
All right. And
all right, thanks so much.
Thank you.
Welcome.
And we had the Telecommunications Director, Mr. Bennett Thomas, and the Executive Director of the National Telecommunications Regulatory Authority, the NTRC, and that was Talking Points.
In September 2017, our lives here in Dominica changed forever. Hurricane Maria took our homes, lives of our loved ones, and left us with billions of dollars in damages to repair.
We at Flow were not immune to this destruction, but we made a promise then and there to rebuild with